One, Alberto Martinez. All right. Hi. So on this case, do you have all of the discovery?
Judge, I got handed a hard drive last week that had 431 PDF files, 98 videos, and 94 images. Uh, that was the requested discovery that I had asked for back on July the 8th.
Yes.
And so I have not yet had a chance to review all of these.
And I appreciate the fact that you said I will turn over a hard drive later in the day, back in July, and you did it. Sometimes people will say, no, I have a hard drive now, so I appreciate that. So how much time are you asking for to review that?
Judge, 30 days is what would allow.
All right, Ms. Ferguson, I need a 30-day reset.
And Your Honor, also, I've already filed motions on this case.
Right, just 1 second. Excuse me, sir. Here's the thing. Do you want your attorney to go without having reviewed anything? What he has to review is a lot for him to review. If you want your attorney to go to court blind and be surprised by whatever the state presents, we can do that. But you're not his only client. So the fact that he has all of that to review, he needs to review it to be effective for you. You may continue.
Judge, I filed 17 motions this week on this case. One is a motion to suppress. The other is a motion to reduce bond. And at the court's schedule, I'd like to schedule those as early as possible.
All right. So, state, with regards to the motion for the bond reduction, have you had a chance to review that, and would you be ready to proceed on that?
Not seen that, but if I look at it, Judge, I can be prepared for it.
All right. So we may be able to take up the motion for bond reduction to the motion to suppress.
This is where strategy comes into play. A motion to suppress can be a case killer. If evidence gets tossed, the whole prosecution can collapse. But notice the judge's realism. This isn't just paperwork. This means witnesses, testimony, and time. Meanwhile, the bond issue, that's immediate. Freedom first, courtroom battles later. Smart sequencing by the defense here.
I know the state is not going to be ready for that. I'm assuming there will be witnesses needed.
Absolutely, Judge. The judge will need, I'm sorry, the state's going to need at least a week, I think, to get ready for
All right. Because I'm assuming it's not just a search warrant where I can read it and say yay or nay. So we're going to come back on September 29th. Is that good for you?
That's the judge.
All right. And then state on September 29th, if you haven't done so, you'll need to be able to tender offer on that day. And an acknowledgement of discovery will be need to sign on that day. All right, so if y'all have a seat and if you'll confer with them on the bond, the court will hear the bond matter.
Sure. You're
welcome. All right, the court is calling 2025 CR 004887, State versus 1, Alberto Martinez. Could I have parties announced for the record?
Jason Gearhan for the state, Your Honor.
Robert Covington, Mr. Martinez.
And you are Mr. Martinez?
Sir.
All right, your attorney has filed a motion for a bond reduction. State, have you had a chance to review the motion?
Yes, Your Honor.
And do you waive notice?
Yes, Your Honor.
All right. So according to this, your client is charged with manufacturing, delivery, controlled substance penalty group 1. Let me see. Over 400 grams?
That is correct, Your Honor.
Over 400 grams. Bond is currently set at $25,000, according to your motion, and you're asking for the bond to be reduced. So
there it is,
we're
the
going to
number
come
that
back
changes
on September
everything.
29th. Is that
Over
good for you?
400 grams isn't just a quantity.
All right.
It's
and
a
then
top-tier
state on
felony
September
threshold.
29th,
In most
you haven't done
jurisdictions,
so, you'll need to
that's
be able
prison
to tender
exposure
offer on that
measured in
day.
decades, not years.
And
So when you hear a
an acknowledgement of
$25,000
discovery will
bond,
be need to
understand
sign on that
that
day.
bond.
That's correct, Your Honor.
All right. Do you have any witnesses?
No witness, Mr. Martinez.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. State your name for the record.
Alberto Martinez.
All right. Counsel, you may proceed.
Thank you, Your Honor. Mr. Martinez, you have a great concern about a family member. Who is that?
My mother was diagnosed with cancer a week ago, and Mr. Person has been doing a lot for me. So if my patient's been turned over, I mentioned the discharge, but I'm pleading to the court And then the way that you all told me, I mean, I'm willing to do anything you would say, but I am my mom's oldest son. She doesn't deserve to die alone. But I am sorry that I would plead no contest to the court. Whatever, somehow I can get probation, whatever position you put, whatever. Whatever.
This is not.
This is one of the most emotionally raw moments in the hearing, and also one of the most dangerous legally. You can hear the desperation, but you can also hear confusion. Innocence, no contest, probation, all blended together. Judges feel empathy, yes, but they decide based on structure and law.
No, but I understand that's the problem with my mother. She got cancer. That's what he's stating. My mom.
You're right. Please report. He's under a great deal of stress because of this issue on his mom. He originally started with the PR bond, and then his bond she asked for a bond increase as a result of some issues associated with his bond. The state will probably go into more detail on that. But we're respectfully requesting that the court consider a PR bond for him. There is no violence involved in this case. And he would like to be able to provide some assistance to El Paso.
Right,
I don't really have any questions.
Yes, perfect. Yes.
all right. So, does he have any funds?
Judge, I'm appointed to his case. He is indigent. And I do not think that he has any funds that he can draw on, considering what has now happened to his mom, which was his sole source of income prior. I don't think that she's going to be able to come up with any money in order to be able to get him out on a bond. He has no bank accounts, no personal property, no real property to rely upon in order to get anything over there.
Oh. So what I'm going to do then is you're saying there's no amount of bond he can make. He needs a PR bond. Is that correct?
Yes, sir.
This is a quiet win for the defense. A PR bond, personal recognizance, means release without posting money based on trust and evaluation. It's not automatic. It's not guaranteed. The judge is saying, I'm open to it.
All right. So in this case, Ms. Ferguson, have him evaluated for a PR bond. And once the evaluation is complete, we'll have him brought back. It shouldn't take that long.
You're out in the most time going back to court.
All right. So, Norm, I want him evaluated for a PR bond. And then we'll place him back on the docket as soon as that completed. It should be done by next week, hopefully.
I'm not judging you every day.
All right. Thank you. Ade? All right. Yes.
I believe you had a discovery, study, preserve, study with, study,
Yes.
we got a offer sheet that was a document, we can lay that off. I believe that we see all this discovery opportunity to discover and develop support. I believe the client wanted to support the, rejects the offer.
All right. So do you want a jury trial or a bench trial?
Man, look, I feel like I'm being coerced into time for something that.
Now, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once the grand jury indicts the case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. He gets assigned to a court. And then you get assigned an attorney. And you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So, whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So, railroading.
This is the courtroom reality check. The judge isn't siding with the state. She's laying out the rules of the game. An offer you don't like isn't coercion, it's negotiation. And here's the tension point. Once the offer stops moving, your leverage shifts to the jury box. 12 strangers. One verdict. High stakes.